You love News at Prime. It's a pleasure to have you with us tonight. I'm Kathy Mutlahlana. Judge Tshifhiwa Maumela has told defense lawyers in the Senzo Meyiwa murder case that the court has no jurisdiction to release the accused without giving those that arrested them a chance to respond. It comes after Advocate Malesela Teffo made a number of submissions regarding the violation of the rights of his clients. Five men stand accused of murdering the Bafana Bafana captain in a purported robbery in 2014. The matter has been postponed until tomorrow, where a way forward is expected to be mapped. Well, let's try and make sense of today's proceedings. We're joined now by reporter Mnisi and legal analyst Advocate Romeo Nthambeleni. Good evening to both of you. Thank you so much for your time. Linda, first let's just kick it off with what unfolded in court. Of course, this issue of the second docket was always going to become a sore point, especially for the defense, because ultimately, if they're able to prove that this docket has legal standing, that it gives their clients an opportunity to get off, because that docket points to a completely different set of suspects.
Indeed, and that's why Advocate Mshololo Kathy wanted a confirmation or even clarity in written form from the NPA in terms of the status of that particular docket. Today we heard the NPA writing back, given the fact that there's quite a number of issues that are involved. If you look at the theory of that docket, if you also look at the suspects who also happen to be victims and witnesses in the 636 case, being the case that is against the 5 men that are currently in the dock on trial. So today the NPA coming back with a response, a written response from the DPP in the South Gauteng division, saying that in fact that particular docket has no status, and that based on what the junior state advocate has said, is that it has basically no merit. But we heard Advocate Mshololo saying that she still needs to go through that particular docket and peruse it, and would request more and more particulars in order to be able to proceed. Her intentions are to continue with cross-examination when it comes to that particular docket. Let's take a listen to what the NPA had to say.
This office did not make any decision or otherwise regarding the case docket. Number 3, my lord, the alleged documents do not have any status as such was an internal opinion from a junior state advocate, which was without merit.
All right, so that's Advocate Mshololo then reading out the response that she received this morning from the NPA, talking about the status of that particular docket. But like I said, she's intending on going forward. She did indicate that the decision to reveal this particular docket now has an impact on this case, because she says it means then they'll need to go back to issues of a pre-trial conference and dealing with all the legal processes before they can continue.
Advocate Nthambeleni, let me bring you in here. I mean, it's clear from part of what transpired in that courtroom today that the NPA has not covered itself in glory, and that there are things that they need to have handled at the beginning of the trial, including furnishing all of the legal representatives with the necessary documentation, that did not happen.
Yeah, absolutely. Good evening, Kathy, to you and the viewers. It looks like the pre-trial procedures were not done correctly, because now we couldn't be in the middle of the trial when it has already started, going back to pre-trial proceedings. So it clearly indicates that the NPA did not cross their T's and dot their I's in relation to the proceedings of this matter, because we had this long-standing issue of the second docket, and it is being clarified now in the midst of a trial, which that was not supposed to be happening, because the pre-trial proceedings actually are, in terms of the rules of the court, made for you to actually, determine the readiness of the matter before the matter proceeds, in court. And it's quite, belated that now we see a letter where it is indicated that the content of those docket will not be, proceeded with, and rightfully so. The defense still has to actually read the contents of those docket and see how it actually relates to the to the case and the charges that are being professed against accused 1 to 5 that are before court. So unfortunately, this rigmarole has been started from the beginning, and it's unfortunate that you can't unscramble the egg at this stage now.
Well, while the contents of that second docket may have been put aside for now, the defense has already indicated that they, and when you listen to Advocate Malesela and Advocate Mshololo, both are making an argument around the aspect of justice, fair treatment and constitutionality of these processes as it affects their clients. And one would think that it's not going to be something that they let go of very easily. What does that do for the future of this case?
Yeah, okay, so from what you're saying, we might be facing a mistrial in our midst here. And then, you're correct to indicate that the legal representatives, both of them of accused 1 to 5, have indicated the infringements of the rights of the accused persons under the Constitution. And there is no doubt that this is playing out now from what we are actually witnessing in court in terms of the trial proceedings, and what we are actually saying now, that things that were supposed to be done in a pre-trial are being done in the midst of a trial, which ought not to actually happen in the case. And how the case is actually being conducted at the end of the day is becoming a bad reflection, not only at the NPA, also with the police. And we have seen the witness that was being cross-examined, and the things that came out. So it's quite unfortunate that we are finding ourselves in this kind of a situation, that when you climb a tree, you don't start on the leaves. You have to start down, going up. And it seems like this one has been started upwards, going downwards, and it's creating a serious procedural irregularities that actually affect the constitutional rights of the accused persons that are on the dock. Because we're still questioning ourselves if these accused persons that are on the dock are really rightfully the accused persons that are charged. And we are in the early days of the trial, and only one witness has been called, and we don't know what extra evidence the state has, which can lead to a discharge. Because, and as you have been saying, that Advocate Malesela Teffo was asking for a discharge. So let's see what the state has. Let's see if ever there are other witnesses that are going to implicate the accused, and connect them to the crime scene, and then I think we can take it from there. But with one witness, we cannot be able to make that determination now.
Well, Linda, one of the other moments that would have struck or caught the eye of viewers is the exchanges, sometimes very difficult and tense, between the judge presiding over this matter and Advocate Teffo.
Absolutely. And when you look at today's exchange, Kathy, talking about procedures that need to take place in court, you'll remember that it's not the first time that we're seeing this kind of exchange, particularly when it comes to issues around, applications made by Advocate Malesela Teffo, or when he's supposed to be making submissions to the court. Today was in relation to him, standing up and addressing the court when in fact it had not been his turn. And those are the issues that started that heated exchange between himself and the judge, and he feels that he was excluded given the fact that there was, of course, that exchange between Advocate Mshololo as well as the prosecutor, George Baloyi, around whether or not the state did provide the docket to the affected parties. And Advocate Malesela Teffo felt that he was being excluded because he was not being given the chance to speak and address the court on issues that affect his client, and went back to the issue around his client's rights being violated, and the fact that as someone who has been tasked with defending them, he ought to speak. Let's take a listen to that exchange.
Lordship, I still feel great as accused 1 to 4 that we are definitely being excluded from this proceeding by this court.
Okay.
But there are very
if you are not going
issues.
to respond to what I asked you, sit down. Sit down, Advocate Teffo. If you are not going to address dates, sit down.
I cannot be forced.
Unless you want to be in contempt of this court. I asked you a specific question. If you are not answering me on that, sit down.
Lordship, the best way, let's go to the chambers.
No, I'm not going to the chambers. About you trying to undermine me in court. I'm not going to any chambers.
But now the accused 1 to 4 has been undermined here. We
Sit
cannot
down. Sit down.
we cannot prolong this this case.
Sit down.
Yeah.
Advocate, sit down.
But I don't agree to that.
Of course, Advocate Nthambeleni, that was just a build-up from what we saw earlier on in the day where Advocate Teffo had stood up and said, well, he's asking to be recognized because he felt that the judge hadn't recognized him the entire day, wanted to make, again, submissions on behalf of his legal representatives. One has to wonder, you know, when a court issues certain warnings, particularly to legal representatives of those who are in the dock, does it count against them, the fact that it's not just today that it seems the judge has had to rein him in somewhat?
No. Thank you, Kefe. Not necessarily. You look, you know, as legal practitioners, we know, the rules of the court and what is required, for you to do. That is what you are taught when you're doing trial advocacy. And the minute there is an exchange between you and the judge, it becomes problematic. And the way in which it was playing out in court is not supposed to be like that, because you are both officers of the court, and what ought to happen is that you all need to see justice being done. And then all those are kind of issues and the exchange that were actually happening were actually unnecessary, because one has to know actually when not to interject when the judge is dealing with the matter, and also allowing the judge the opportunity to actually preside in his matter, because I've seen him most of the time, indicating that you are not going to tell me how to actually run your trial. So there are boundaries that ourselves as legal representatives, when we are practicing, we are not allowed to actually not pass. And then I'll give you an example. When I have an instructing attorney who is with me in court, my instructing attorney is not allowed to address the court, by the way, because I'm on brief, and I cannot, the court cannot be addressed by a person who is not, presiding before it as a legal representative. So that kind of etiquette and the rules are standard rules when you are quite familiar with the rules of how to actually conduct trials, and it makes matters to be easy, and the judge to be in control of the court, because the judge normally does not interfere unless there is something that is completely untoward that is actually going on in terms of our system.
So, Advocate Nthambeleni, are you saying that what we saw earlier on in the day, when the instructing attorney of Advocate Teffo, stepped up to explain why it was imperative that the judge hear Teffo out on the matter, and as far as making submissions on this issue of the second docket, are you saying that that's not the way it would usually go?
Yeah, it's not the way that it usually goes. Normally, when we appear like that, the judge will even ask you a question: who is appearing? Is it you or your attorney that is actually appearing? Because when you have an instructing attorney, the instructing attorney's duty and function as counsel is to give you instructions that you relay to court. So you will never find a scenario where you find an instructing attorney and the counsel addressing the court at the same time. You'll never see that happening.
Linda, the big question is, what happens then tomorrow?
So you'll remember then, ultimately, Advocate Malesela Teffo was allowed to make his submissions, and he made a number of submissions, particularly around his client's rights and the issue around jurisdiction. And that is why we're seeing this court not being able to deal with the issue around the lengthy postponement that was asked by Advocate Mshololo. So he's made a number of submissions which the court needs to then sit and discuss tomorrow. And ultimately, when we return after tomorrow's postponement, we're going to hear the arguments based on the submissions that were made by Advocate Malesela Teffo. So tomorrow is just to chart a way forward in terms of when that application will come, when answering affidavits will be submitted, heads of arguments, and then ultimately deciding on the day to come and argue in court.
Advocate Nthambeleni, let me wrap it up with you. Is the future of this case in jeopardy?
Yeah, from what we are seeing now, it appears so, okay. And then I don't know how it will proceed under the circumstances, but it looks like when those things are threshed out, there will be some light now that there is clarity in relation to the issues relating to the second docket. So let's see how it will pan out in the end.
All right, let me thank you both for your time. Linda Mnisi is our reporter that has been tracking the story, and you heard there from Legal Analyst Advocate Romeo Nthambeleni.